Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Mema wakwaba ede ba PENDREAM TV so make sure say obe subscribe to channel no click bell so say the news to our sabe to me aka ntem no watie Afia so make sure say obe like na wa comment no share ama afoforo so nsaka na comment section ho so no opese wo kire wa adwen obetimi ede wa adwen kire ato honom na amanfo so anya bia kenkan na onim say PENDREAM TV there eye nsem a ekoso Ghana yam politics mu ne ede ba na yasaka ya na ede abranti na so me video I saka pese no che na ye dey ba nti me mo modern astro so obehwe video we amana si awie na wa kire wa adwen e comment section na say yenko video.
Is it just about professional misconduct or something more than that?
Oh, it's obviously something more than that. Obviously, you're talking about the realm of criminality. One,
how does this border on the realm of criminality? One,
you find the Attorney General telling the so I'm calling him witness, meanwhile he's third accused. Of course, witness because he's in the box. Telling the third accused to answer in a certain way the Attorney General wants him to answer. When that's Jakpa, is not comfortable with what the Attorney General wants him to say. What is that? He says, you want, so Jakpa, you play that side. Can we get that specific side? Saying that, oh, you mean you want me to answer your way? Then Dami hesitated a bit and yet said, yes. Okay, let's take it that way. It ended up with a yes. That is the kernel of the matter. The judge didn't refer to it. So I'm like, maybe the pressure, because to give 2 days for such a weighty ruling, for me, it was too short. So there were bound to be mistakes. I knew it. I was like, no, this thing, 2 days, are you sure? Because it's too much. And you know, in the process, what we are not discussing, what viewers don't understand so far is that there was a great travesty of justice. The judge did a lot of injustice to the accused persons.
You say the judge did a lot of injustice?
Injustice to them. The ruling itself, I won't be surprised. They actually will have to go and challenge it. She did something fundamentally wrong. It was so wrong that I was like, why? Where is she in a hurry to go? Listen, when you put stuff before a court, this is my application, okay? I want you to do stay of proceedings. What you put in there, usually we don't put law in the affidavits. No, usually except some exceptions. So generally we don't. So the arguments of the lawyers are not in what she took. So you come to court and then you do the arguments. So based on the affidavit, you say, okay, I said we met here and here. He tried to coerce me or whatever to answer in this way. So after saying that, then you say, to persuade my lord or my lady, I have the following cases. So then that's when, and then law. So that's when the real meat of the matter is done. They just didn't allow it. I don't know where she was rushing to. She didn't allow it. That's so fundamental. So everything about this ruling, no. We haven't heard, that's not the best.
So you were expecting that what? The lawyers for both Richard Jakpa and also Dr. Kesela Tufosin will argue out their case?
Yes. That is the real matter, because then that's when they would come with all their cases. Yes, my lord, this case is like R.V. Maxwell. In Maxwell, this and this prosecutorial misconduct happened, and this is what the court in the UK said. This is like R.V. Mohammed. This, so many, and those cases, there are many. I mean, I did a case in that area. You see, criminal disclosures. Yeah, I started it. I mean, there was a high court decision by Justice Ajit Nassam, but people didn't like it. So we decided to go to the Supreme Court. Even in the Supreme Court, this whole area, this prosecutorial misconduct is a critical part of criminal disclosure.
But have we developed that?
Not at all. In the Supreme Court, before they came out, it took about 2 years. They were reading over and over and thinking about it deliberately, carefully. 2 years. So, and this prosecutorial misconduct area is a huge part of it. So I've been familiar with this area. You don't, in 2 days, giddy. It's as if Ghana is coming to an end. I don't understand. And so when you do that, you make mistakes. Can you imagine somebody like Tadio, sorry, you ask a lawyer, and a lawyer who has practiced a few years will tell you they no sorry. Sorry is done brilliant cases. Stalwart at the bar. Sorry is coming to address you and you say, no, I won't take anything from you. Aziz Bamba, Eduji and Co. You say, no, don't address me. I know it all. I'll do it by myself. That's not law. That's a breach of the right to be heard. And you know what happened? So, Sorry even went to the Supreme Court. He filed an application for prohibition to stop the judge, that they should stop the judge, and so the judge would take arguments from them. He mentioned it in court. The judge brushed it aside and went, oh, it was bad. It's really bad. I'm being very charitable. It's bad. We can't encourage it in our judicial system. Even Supreme Court. Look, I always know this prime. Look, some years ago, that time, Dami was, when NDC was in office, I think sometime 2014-15, one case he was doing. Supreme Court, you know, Dateba, there was a point where, like, they will ask you, have you given all your arguments? I'm talking about Supreme Court. Have you presented all your arguments? If you want to add, even the day you come to court, you want to orally add, they will take. The point I want to make is that Dami brought more cases, and Dateba, old man, kept writing. At a point, my heart skipped a few beats because that, when this man said that, Dami, all this why are you now bringing plenty cases? But patiently, Dateba, Professor Dateba, he kept writing and wrote everything down before they adjourned for ruling. So the haste in this particular application is mind-boggling. 2 days. You don't want to listen to sorry. That's why I say you ask, who is that your sorry at the bar? No, sorry is not a pushover. He has a good track record. Brilliant lawyer. Listen, Dr. Aziz Bamba, he's lead lawyer for A3, right? Supported by Eduji. Aziz Bamba taught me over 20 years ago. These are good lawyers. So it doesn't matter, even assuming these guys, even I'll make the same argument, even if the lawyers were just 2 years old at the bar. I'll make the same argument because, listen, the client, the accused has a right to be heard. It doesn't matter, even if the lawyers speak nonsense, assuming, without admitting that what they are coming to say is all wrong, you will hear them, record the arguments, and then answer. That is the hearing. Then they've been heard. But this one, she didn't hear them. They didn't get to present their cases. So when you read the judgment, it's one-sided cases she knows. As she kept reading the judgment, because I've done research in this area, almost a decade now, as she read, I also remembered my own cases. I was like, but you've not seen this case, you've not seen this, you've not, you see that. So if she had listened to sorry and the cases sorry has, listen to Aziz Bamba and Eduji, and then all the others, and Dami himself, I'm sure he too would have had cases, etc. The judgment would have been richer. So this don't expect this ruling to be the last. That's not the last. Definitely, this will be headed for the Supreme Court. Listen, and even the Supreme Court, even if they lose, it still doesn't wipe the fact that they've suffered great injustice.
Do you
because the application
more of a judicial review of this?
Absolutely, no. And I'm saying that even if the Supreme Court were to throw it out, Supreme Court, the judicial review, it's a discretionary thing, so they can look at many things and still throw it out. I'm saying that even if it's thrown out, it doesn't wipe away the fact that they were never heard. And that's a bloat. It's a big bloat. Such a high-profile case. Why was the judge in a hurry to go? Why? Is Ghana coming to an end in 2 days? Why?
But if you take it, then the point you make is that because our criminal jurisprudence, we haven't grown, or
yes,
as it were, we haven't developed when it comes to criminal disclosures.
Yes,
you would have expected that there are more cases that would have been considered.
Yes,
in arriving at this judgment.
Absolutely.
Is it just an approach, in a difference in approach, or the judge did not do right? Because
the judge didn't do right. There's no way you can defend
she made
this.
references to certain cases that also led to her conclusion as well.
Absolutely. So that's what she thinks. But you also have to give the lawyers the opportunity to give you their submissions.
Right.
The cases. As I said, as she read, because I also know that area a bit, I also remembered my own cases standing there, though I haven't referred to my manuscript for some years. But when you write, you sit down and research, you always remember a lot of the stuff. You can't remember everything. But as she went, how she had. So I also looked at other cases, people who were even underlings. In the UK, you have the Guildford 4, you have R.V. Maxwell, R.V. Mohammed, so many of them, where they say, no, we'll quash this conviction because the prosecution was engaged in this underhand dealing, because this evidence was suppressed. This tape is so serious. Look, even I would have expected a judge to say, look, apart from the lawyers in this case, any of you seated here, if you have any idea you want to try an amicus curiae, of course, I know there are limitations, but I'm just stretching it that sometimes for a huge public interest case, you can even invite other lawyers who say they want to have a say. But as I said, please, let's be careful. That's not my main submission about other lawyers coming. We wish the law would develop to that extent more in criminal practice, but that's not it. Let me just stay within the main thing. I'm talking about here the lawyers of the accused persons. That was not done. And it's a huge bloat on the ruling. So the ruling is not as weighty as it should be. Because, so she read a few Canadian cases. As I said, no, it wasn't rich enough. It wasn't. Nah. Listen, that's what I said. So it's not, I'm not saying that by all means the submissions that Sorry and Co would have made would have swayed. No, but at least she would have seen other perspectives. And even if she would throw them out in the ruling, she would have raised them and answered. And then we would all be richer for it, because then we would see that, okay, this case we've been reading and thinking this is what it means. The judge is seeing something different in it. That's the whole thing about in law. We are always learning. So this ruling, it doesn't carry as much weight as it should, because it's not been fully argued. It wasn't argued. And as I said, I'll be surprised if none of the lawyers takes this matter to the Supreme Court. And even if they go and they lose, listen, it will never wipe the fact that the lawyers were never heard. So for decades to come, this will be a bloat. Bloat. It's not good at all for our justice system.
May I say something?
No, I want to just let's see just conclusions or certain aspects of the ruling, and then what Lawyer Kpebu is talking about. Let's take a look at this. On the Atoforsen's application for an order of inquiry into the Attorney General's conduct, which was dismissed. Let's look at excerpts of the ruling. It says, to conclude under this head, I quote, hold that there is no legal basis for a court in the course of criminal proceedings to order an inquiry into the conduct of a prosecutor. There may be another forum for such an exercise, but these criminal proceedings cannot accommodate it. Let's go to the next one. It also talks about the issues of jurisdiction. And Lawyer Kpebu, you see, the judge in delivering her ruling, in that aspect that you say that at least they should have been heard on some of the aspects of this case, says she listened to the tape 10 times.
And she got it wrong. She got it wrong. Need to hear that me say, yes, go my way.
Yes. For instance,
can you play that side?
The aspect of the assistance to implicate Atoforsen. It says what was not born from the Attorney General, but from Richard Jakpa, and give the minutes for that.
It's not about the minute. When Jakpa said, please, I hope your producer is arranging that side so that we play it. When Jakpa said, do you want me to answer it your way? What did Dami say? He hesitated. Let's say, yes, he ended up agreeing. I'm sure it hit him. But he still didn't see what he was doing, that he was in the realm of criminality, right? Now, look, this tape is embarrassing us as a nation. So the more we try to spin it and try to do all this, I cringe. I'm like, what are we doing? So it means that for this current administration, they will never accept any, defeat. No defeat at all. So the thing is that it's serious. It's serious. This matter, don't play. The fact that the accused wearing head, no, it's a serious matter. It goes to the root of everything that happened on Tuesday and then on Thursday. Okay. No, it's not good. I hope that, as I said, moving forward, perhaps they will get justice in another forum. Because you have to hear the arguments of the lawyers, especially as I said, look, we are behind. Mr. Kansi, that was your question. We are behind in this area of criminal disclosures, etc. At the time we're going to ask for criminal disclosures in the Supreme Court in 2016, by then, Gambia, even look, Yaya Jammeh's Gambia, they were ahead. South Africa, about 20 years. Namibia, because South Africa, their decision was in 1995. Namibia, 1993. You come to Kenya, 2007, etc. Many Malawi, can you imagine? Bakili Muluzi's Malawi. The reason I remember is that growing up, I mean, we used to laugh at this in countries like that. Not knowing when it comes to criminal disclosures, they were way ahead, etc. So this area is not developed in Ghana. So that's why earlier on I even stretched it by saying the judge private said, look, I'll make an exception. Any other person who has an opinion can wade in. I mean, but as I said, that's not law. But let's concentrate. Minimum, there was a requirement to listen to the lawyers in the case. That wasn't done. They didn't get to present their arguments. So how can the judge know what is in their heads and then answer in the ruling? How? The affidavit doesn't say all of it.
Right.
It doesn't at all. Far from it. As I said, the affidavit doesn't address law. So address your facts in the affidavit. Then you address the judge orally on your law. If the judge wanted to have said, oh, maybe, okay, do written submissions. Look, and let me add this final point. Even when in law, when let's say today somebody is building on your land and you go to court, you say you want injunction. As part of the injunction application, there is a part where you have to argue your law. It's called statement of case. Even in injunction applications where you have statement of case, most judges will still give you an opportunity to address on law if maybe there's anything further beyond what is in your statement of case. That is a practice at the bar. So for such a very sensitive, high-profile matter, for the judge to just assume that she knows it all, she doesn't need the submissions of the accused lawyers, Charlie, don't play. It's drawn us back.